The Ohio man dubbed the notorious railroad spike killer has been released from death row, and get this, he's now on house arrest while he awaits his new trial. 59-year-old David Lee Myers was sentenced to death in the 1996 killing of 18-year-old Amanda Jo Maher. The teen mom was found partially naked near railroad tracks with a railroad spike in her temple and 3 stones in her vaginal canal. Police say that Myers was the last person seen alive with the victim, but a new trial was granted for him earlier this year based on some brand new DNA discovered from the railroad spike and on a rock collected from Maher's body. The victim's daughter spoke to station WHIO, who was the victim's daughter was just an infant when her mom was murdered.
I try to say I prepare myself. I wasn't prepared for that. It seems unreal. We don't know him except for being behind bars for 36 years.
Now this morning we're asking the question, how does a man go from nearly 3 decades on death row to now being on house arrest? Let's bring in our power panel now. Still with me, attorney C.K. Hoffler and Chief Chris Anderson, and want to welcome in trial attorney and law professor Dante Mills. Dante, would you start us off with the discussion, please? So there was new DNA testing that seems to perhaps vindicate this guy, and his lawyers must have done some good arguing because now he's home as he awaits trial number 2. Would you kind of walk us through whether this is okay?
Absolutely. Good morning, guys. When you talk about having someone, their conviction overturned, it takes a lot. I've recently had it done, and it was a lot of work to show that and not only was there something that happened during the trial or some evidence that comes out that would have impacted the outcome, but you also have to show that moving forward, it will be different. And in this particular case, what they showed is that the DNA from the murder weapon, essentially, that railroad spike that was found in the victim's temple, and the stones that were recovered from the scene that were also used in the assault and the murder, did not have DNA from the defendant. That is significant because what you're saying is what was used to kill this person, the defendant did not touch that at all. Somebody else did. It's DNA from another male. And if that's the case, I'm arguing to the judge that the likelihood that my client will be convicted in another trial is slim. So he should be afforded the right to fight this case from home, and that's what the judge decided should happen. It should be noted that in this particular case, he was charged after the murder in 1988, but the charges were also dropped. And then they brought the charges again 2 years after dropping them. So you have to wonder whether there was already some issues with the charges themselves and the proof that they had, but they just simply used DNA evidence, which was looked at completely differently around that time. And now that you have exculpatory evidence saying that there was someone else's DNA on the murder weapon, I think the right thing to do for this judge is to allow this defendant to fight this case if they bring this trial again from home.
A great explainer. Dante, thank you for all of that and the information about the charges initially being dropped. That could signal something potentially. CK, would you help us take it a step further? So these attorneys representing him have to be encouraged by this news. And now, 30 years later, what advantages do you see in this second trial for this guy?
Well, absolutely, Julie. I think they really did an incredible job. I agree with you. I'd love to see their arguments because they were very compelling. And what I've read about their arguments, they were very compelling. And certainly if there is exculpatory evidence, I agree. Even though this to me is very difficult to fathom, but I think he will get another shot at this. So I think going forward, the advantages are that technology and what we have to be able to examine DNA evidence. When we look at a case now, 36 years later, there's an ability to be much more progressive in the processing of evidence, even if it's old evidence. And so the fact that there's new DNA evidence, other exculpatory evidence, certainly does help this defendant. As heinous the crime and the evidence, I think there was pretty compelling evidence in the first to have him convicted in the first trial. But however, he was on death row. So when you have there's a modicum of evidence that's exculpatory when you're on death row, I certainly think that he is deserving of a new trial. House arrest, I can tell you I'm not sure about that. But again, I'm not the judge. But I think he will have a great deal of advantage because of technology, because of how evidence is processed today versus 36 years ago.
Excellent point. CK, thank you for all of that. And here, certainly it's encouraging that this DNA isn't a match for him, but does it mean we throw the baby out with the bathwater? Chief Anderson, I want to go to you, please, for a law enforcement perspective on this. If he's not the guy, then of course we know what that means. We know that police and prosecutors got it wrong. Would you talk to us a little bit about what investigators are doing now, cracking open those old files from 30 years ago?
Mm-hmm. Absolutely. So, before I get started, I just want to offer my deepest sympathies to the daughter, Sarah Sparkman. She was only 8 months old when this murder happened, when her mother was murdered, brutally murdered. And according to some of my readings, that she was still pregnant. So she not only lost her mother, but she also lost an unborn sibling. So I want to send my deepest sympathies out to her and her families, because when you have a case like this where you've been fighting for almost 40 years to keep someone in prison, and then they get out, it just opens up so many different wounds in the victim. Now, as it pertains to the investigators have to go back to square one, because that is the only way that you can fully investigate a case like this, or reinvestigate a case like this, to see what else was missed, if there was anything else. I think CK and our other power guests did a great job of explaining things from the law side. But as an investigator, you have to go back to the beginning to see if there was any other evidence. Because back in 1996, back in the early 80s, DNA was in its infancy. And if that evidence was utilized to convict someone and it was incorrect, then of course, and it's hard for me to say this, but of course this person deserves a new trial. Him being out of prison, that's debatable, but the judge's orders are the judge's orders. So from an investigative standpoint, you have to go back to the beginning, see if those old investigators are still alive, to talk to them and go back and talk to any witnesses or any people of interest that were involved in this case, and to see if anything was missed. That's the only way that this case should even move forward.
Chief Anderson, a great explainer, and thank you for the sentiments that you shared. I know we all certainly feel that way. This is heartbreaking. That poor child, now an adult, wrestling with this. Was he the guy? Wasn't he the guy? As you said so beautifully, our hearts go out to her, because her mother deserves justice, whatever that looks like.